Tonight, more startling revelations emerge in Cecilia Dapaah stashed $1 million scandal. A special prosecutor discloses how the former sanitation minister allegedly used false names to conceal suspicious real estate transactions. We have exclusive details from court documents filed by the OSP that also reveals how bundles of cash in multiple currencies were concealed in wraps, polythene bags, clothes, and 32 envelopes buried in a former minister's home.
This is Top Story with Evans Mensah.
And Top Story is always brought to you by Vodafone. The special prosecutor may have lost in his initial attempt to get the court to confirm the freezing of former sanitation minister Cecilia Dapaah's bank account and the seizure of her property. Well, tonight it has emerged the special prosecutor is back in court in force with the gloves now fully off, throwing everything at Madame Dapaah. Exclusive court documents secured by Joy News Review. More startling details in this stashed $1 million scandal, with the special prosecutor disclosing how the former sanitation minister allegedly used false names to conceal suspicious real estate transactions. The documents also disclose how bundles of cash in multiple currencies were concealed in wraps, polythene bags, clothes, 32 envelopes, and buried in a former sanitation minister's home. My colleague Elton Brobe has been poring over that document and joins us on Zoom right now. Elton, a lot to go through. Let's start with one of the key issues that we read about in this particular document, and it has to do with the real estate transactions that we're now learning about today.
Right, Evan. So in the document filed in court by the OSP, motion that will be moved on the 18th of October, the OSP says that its criminal intelligence further suggested that the first respondent, that's the former Minister for Water and Sanitation, Madam Cecilia Dapaah, as a Minister of State, was engaged in an undisclosed and undeclared real estate business in which she obscured and concealed the transactions by employing the use of aliases to avoid detection of the actual ownership of the business and properties, whilst cleverly receiving the proceeds of the transaction in her bank accounts and investments as well, Evans.
And indeed, the special prosecutor gives us a bit more detail. It gives the court a bit more detail to justify this particular point that he makes. And one of the details that he provides relates to the respondent, that's the Madame Cecilia Dapaah's selling of a Snit Boteman estate flat. And it says that flat was sold under the name Nana Ya Ode. Now, indeed, and I'm quoting the special prosecutor here, it says, indeed, Cecilia Dapaah appended her signature on all relevant correspondence with the buyer under the name Nana Ya Ode. Concerning the payment, Madame Dapaah, through her agent, gave the buyer her bank account number. It was only at the point of payment at the bank that the agent of the first respondent, in this case, Madame Cecilia Dapaah, revealed to the buyer that the true identity of Nana Ya Ode was the first respondent, and that's the former sanitation minister, into whose account payment of the purchase price of 117,000 cedis was to be made and was effected. Now, the special prosecutor says a copy of the investigation statement of the buyer in question is attached. In other words, they have investigated this and spoken to the buyer, who had given them further evidence, which they are placing before the court. They also marked an exhibit while the correspondence on the transaction signed by the first correspondent in the name of the Nana Ya Ode is attached and marked as well. So they also have documentation on which they claim to have Cecilia Dapaah's signature, not signing as Cecilia Dapaah, but signing as Nana Ya Ode in this particular instance. Now, they also goes ahead to talk about there's also the transfer of an amount of 149,000 into the first respondent's account as payment order for this Boteman sales account. And this was on the 17th January 2018. they did an analysis of the statement in Cecilia Dapaah's bank account, and the OSP says it was highly suspicious. It was a highly suspicious transaction involving the name of the first respondent's deceased brother. And we'll talk a bit more about that, because I think we're also learning a bit more about the brother who we know is deceased, but as we're learning today, monies were being moved from that account. But I think I'm interested in what the OSP found in her house when they searched the property, and
yes,
where monies were stashed.
Point 14. Yes, so if you look at point 14 of the OSP claims that is before the court, according to the court document, the car's monies were craftily concealed in wraps, polythene bags, clothes, 32 envelopes, and were buried and secreted in an obscure place in the residence, with some labels and descriptions. Audiovisual recording of the search revealing the concealed sums of money are attached in sealed pen drive and marker exhibits OSP2. So I'm sure that when the OSP moved this motion on the 18th of October, they will be doing so together with some exhibits that they are attached, including video or audiovisual recording when the search was conducted in the home of Madam Dapaah.
And Elton, the OSP maintains that these amounts are tainted.
Exactly. In fact, the OSP makes it clear that if you look at the circumstances under which the money was acquired, it raises question. He says that the OSP initial issues regarding this matter was to ascertain the money involved and also to check whether it came from legal sources. And from everything that they have done, it doesn't look like there's not enough evidence actually backing this particular matter in question. And it goes on to make some claims here, Evans, if I should just go. It says there are no financial records and traces of origins of the money reportedly stolen from the residence of the respondent and the money discovered by the OSP at the said residence. Further, there is no evidence of the amount of money having been derived from any legitimate businesses, profession, or vocation, or no evidence of said amount having been lawfully declared and subjected to any statutory payment. During the search conducted in her presence, the first respondent, that the former minister, disavowed and claimed no knowledge of the presence of the said cash sums in the residence. The conduct of the first respondent, being a public officer, heightened the suspicion of the authorized officers of the OSP that the cash sum were tainted property. The statement goes to say that in her investigation, caution statement to the OSP during the course of the interview on the 24th of July, 2023, the first respondent, that's Madam Cecilia Dapaah, stated that an amount of $800,000 out of the cash sum reportedly stolen from their residence belonged to a deceased brother, one Nana Akwesi son II, and there's an attached, exhibit that the OSP is hoping to move alongside this motion on the 18th of October. And so subsequently on the 28th of July, in a further statement voluntarily given to the OSP, the first respondent claimed that the amount of $590,000 concealed in a residence and discovered by the OSP was actually part of the $1 million the respondent had reported to the police as stolen from their premises. By this, the first respondent was suggesting that though the accused persons in the case, and the case is provided, the case in court, in fact, the amount they allegedly stole in the dollar currency was actually $410,000, and they've also attached these as well, Evans.
And the OSP comes to this conclusion because they now reproduce what Madame Cecilia Dapaah had told them during questioning, that the $590,000 that was found in her home is part of the money that was originally stolen, that had been reported stolen to the police. And the OSP then does the maths and says, if that's the case, then the $1 million that we've been reporting for weeks now that had been stolen, it's not $1 million after all. It actually comes down to $410,000 that is actually missing, because according to the on-the-record, investigative and interrogation responses, the former minister says $590,000 $800,000 of the 1 million is still at home, and it's part of the 1 million. That's how the OSP comes to that conclusion, which is something that the OSP is interrogating. But then also, Elting, there are further details also relating to a bit more, and it relates to the issues surrounding the first respondent, that is the Madam Cecilia Dapaah, and
Yes.
$800,000, which is also allegedly stolen.
Yes, of course. And if you, in the words of the OSP, the first respondent feigned having no knowledge of and could also not attest to the source of the cash sum beyond the mere statement that her deceased brother, who she had stated as being the owner of the $800,000 allegedly stolen from her resident-owned businesses. She later required, and plead her constitutional right to remain silent by refusing to provide information on the ownership and sources of the amount of money reportedly stolen from the said premises and the cash sum discovered by the OSP in the said premise. And the OSP again has attached evidence to back this assertion that they discovered in their investigation.
So in other words, the OSP for the first time is telling us that Madam Cecilia Dapaah pled the fifth.
Exactly.
She's not going to give further testimony and incriminate herself, possibly, because, as the OSP says in this court document, she had originally feigned having no knowledge of and also could not attest to the source of the cash sums beyond the mere statement that her deceased brother owned that money, right, that had been stolen. And then she was further pushed and interrogated. The OSP uses the word she recoiled later. And then at that point when she says, well, listen, I'm not going to answer any more questions on this matter.
Yes, Evans. But then there's further, information provided by the OSP in this court document. It says the first respondent, again, the former minister, claimed in Exhibit 5 attached to this, motion that part of the discovered cash is discovered by the OSP in the said residence was proceeds from the sale of a Demacare cosmetic business in 2003, which she kept in her home. This heightened the suspicion of the authorized officers of the OSP since the discovered city currency notes are in the new city denomination introduced in July 2007, and they were not in existence in 2003 when the alleged sale of Demacare cosmetics was reportedly completed in 2003. So there's also issues about the money involved and when the money came into existence.
And
that's also provided
and there's also
by the
OSP. And there's also more on this Demacare cosmetics. The OSP goes on to also say in the court documents that contrary to Madam Dapaah's claim that this Demacare cosmetics ceased operations in 2003, the business registration documents show that the business was registered in 2018. He says further, the first respondent, that is the former sanitation minister, was unable to provide particulars of the said business sale and proof of statutory payment in respect of the said business. I'll take.
Yes, Evan. So, yes. In fact, it goes on to make all these explanations and then also rope in the issue about the sale of an estate by the former minister. And again, the OSP says under the name of Nanaya Ode, and the sale is in reference to a Smith Boteman estate flat number BTOD BLK2 under the name of Nanaya Ode. Indeed, the first respondent appended her signature on all relevant correspondence with the buyer under the name Nanaya Ode. Concerning the payment, first respondent through her agent gave the buyer a bank account. The account number is provided. It was only at the point of payment at the bank that the agent of the first respondent revealed to the buyer that the true identity of Nana Yahode was actually the first respondent, into whose account payment of the purchase price of 117,000 Ghana cedis was made and effected. A copy of the investigation statement of the buyer in question has also been attached by the OSP. There's also the transfer of about 140,000 Ghana cedis into the first respondent bank account details provided as payments for the Smith Boteman sale account on January 17, 2018. Analysis according to the OSP.
There's a very important part that also comes to light in this. We've reported a lot about Cecilia Dapaah's deceased brother. and how in the initial police reports, it had been said there that some part of the monies that were found in a home belonged to this deceased brother. But also this time in this court documents, we're learning that apparently, and from the evidence that the OSP is providing and putting before the courts, monies in the dead brother's bank accounts were being transferred to Madam Cecilia Dapaah's account, even at the time when his death had been confirmed and was still deemed deceased.
Yes, Evans, if you go through the statement, there's analysis of the statement in a first respondent's bank account is highly suspicious transaction involving the name of the first respondent deceased brother, Nana Akwesi Esan II. The said Nana Akwesi Esan died in January 2022. There is no record domiciled at the financial institution of probate or letters of administration granted to personal representatives. Strangely, according to the OSP, there are active transfers from the deceased bank account to that of the first respondent's bank account. Details are again provided. As recent as 19th September 2022 and May 23rd, 2023, an amount of 10,450 Ghana cedis, as well as an amount of 11,284 Ghana cedis, respectively, were transferred supposedly by the deceased brother to the first respondent. And the analysis again conducted on the first respondent bank account, account reviewed the following payment transactions into the account, which are unsupported by the first respondent disclosed lawful income. Deposit of $130,000 US dollars by the first respondent on November 22nd, 2016. A transfer of $100,000 US dollars by the first respondent on the 29th of June 2023. And they've attached the exhibits as well. They've done their own analysis and came to a conclusion that it reviewed that the following transaction unsupported by the first respondent disclosed lawful income. And they've given a breakdown of some additional two payments in a sum of 75,000 Ghana cedis, 54,000 Ghana cedis, respectively made by check deposits into the first respondent's bank account, and another 100,000 Ghana cedis also made into the respondent bank accounts. And also within a period of 5 months, precisely on the 16th of August 2022 and 25th January 2023, transferred by the first respondent from this account of the sum of 300,000 Ghana cedis, 350,000 Ghana cedis, 650,000 Ghana cedis.
I mean, one thing is very clear in this latest court document filed by the OSP. He's gone into great depth, providing details that were not in his first attempt to have the accounts that he's already frozen confirmed. I want to bring in lawyer Bobby Banson now into the conversation, considering that this is the second attempt now that the OSP is making to get the court to confirm the seizure of the property and the freezing of the accounts. Mr. Banson, thanks for your time here on Top Story. Clearly, the OSP is providing greater detail in this latest attempt. Considering that he lost the first attempt, as far as the procedures are concerned, does it make any difference that now he's attaching a bit more meat, a bit more detail to this application before the court?
Hello, Ivan.
Yes, Mr. Banson. Can you hear me?
Yes. Can you just, I lost you for a second.
Yes,
when
I'm just asking. I mean, on the face of the document before the court, the OSP is clearly providing greater detail compared to the first attempt he made. I'm just curious on the procedures. Considering that he lost the first attempt, does it make any difference that now he's adding a bit more meat?
Well, good evening to you, and thanks for the opportunity. Procedurally, he can still have a second bite at the cherry because the application that he filed was not dismissed on the merit to that extent. I think the judge mainly rested his decision on the fact that he had filed out of time. That is one. Two, in such matters, a court does not become functus officio in delivering what may generally be called interlocutory decisions, so that the court has not finally determined whether Madam Cecilia Dapaah is guilty of all the allegations that the OSP throwing at her. You know, at this stage, OSP is seeking a confirmation order to enable the OSP continue its investigations. So it is not as if that charges have been brought against her by the OSP yet. If my memory serves me right, in the evidence that was attached, the exhibits that were attached were the charge sheet by the police, not against the OSP, but to the persons who had allegedly stolen the monies from Madam Cecilia Dapaah. So let's make that distinction. At this stage, the OSP has not yet charged, but is asking for confirmatory orders to enable the office complete their investigations and then prefer the necessary charges. So everything that the OSP has deposed to in the affidavit in support of this application is an attempt to establish what the lawyers will call a prima facie case, to show that the OSP's attempt to... Hello? Evans, can you hear me?
I can, yes.
Okay, to demonstrate that the OSP's seizure of the account is not something that is fanciful, that is being done without any merit, and that he thinks that on the face of the documents that he has, or on the face of the preliminary investigations he has conducted, there is sufficient evidence for him to suspect that if he probes further, he may have more evidence to be able to prefer charges against Madam Cecilia Dapaah. Of course, the application is on notice, and so Madam Cecilia Dapaah's lawyer would have an opportunity to respond to displace that presumption that, okay, if you, on the face of it, you have used this name, you have received money from this account, the burden will shift on you to show that, oh, it wasn't me, or these are the justification. If the judge looks at it, at the document that have been presented, and in the opinion of the judge feels that there is no prima facie case, the judge has the jurisdiction to refuse the application or may grant the application. Mind you, every application, when there is an affidavit in support or in an opposition, the deponent may be cross-examined. So I'm looking at a situation where the lawyers for Madam Cecilia Dapaah may decide to exercise their right to cross-examine the deponent of the affidavit filed by the OSP, possibly to punch holes into them.
Even though this is just an attempt to get a court to confirm the seizure.
Yes.
Is that allowed in this
application? Yes. We can have, for lack of a better word, I would say a mini trial based on that application, because the affidavit is sworn evidence, is sworn testimony. It's as if the person who signed the affidavit is in the witness box. And so if the lawyers for Madam Cecilia Dapaah or Madam Cecilia Dapaah has the strong view that cross-examining the deponent will expose the inconsistencies in the document, they may decide to exercise their constitutional right to do so. If Madam Cecilia Dapaah deposes to an affidavit in opposition, then the OSP's office may also decide to exercise their jurisdiction to do, their right to cross-examine the deponent. But at this stage, the OSP's attempt is to establish a prima facie case to show that his freezing of the account has some basis, even though it is not concluded. It has not concluded its investigations yet. There is enough basis to hold on with the monies or the properties that they think is tainted, and then complete their investigations to enable them develop it further.
And I wonder if it may become relevant in this particular case, considering what the OSP did in complying with the first court order that they lost, which is that release the funds and release the property and defreeze the funds in the account. The OSP did so, but immediately reconfiscated the assets and froze the accounts again. In other words, they got them to sign, but they didn't actually take possession of the property. May that become an issue in court?
I do not see how that becomes an issue. The court order, the previous order, was in response to an application that had been filed by the OSP's office. The court dismissed that application, but the court did not restrain the OSP from conducting further investigations. And so, for instance, if today a police or the OSP's office thinks that I hold tainted property, I go to court, and I have not been charged with stealing as a public officer, as it were, but the OSP goes for these interlocutory measures. The outcome of the interlocutory measures does not create what the lawyers will call estoppel or res judicata, because the court had not determined whether or not Madam Cecilia Dapaah is guilty of any charge. Remember, the OSP had not preferred a charge against Madam Cecilia Dapaah at that stage. So if the OSP had preferred a charge, had actually charged Madam Cecilia Dapaah, gone to court, and the court had dismissed the criminal case against Madam Cecilia Dapaah, then the OSP could not have reinstituted the action with further evidence. That one would have constituted that in criminal parlance they say you do not vest a suspect twice. So that would not have been possible. But in this case, it was only an interlocutory step taken. And a ruling in an interlocutory step does not create that res judicata, because it does not tie the OSP's hands from going back, doing their homework well, and then instituting the investigations again.
Bobby Bansi, thank you very much. And we look forward to this actually being heard in court, and you can trust that will bring you all the latest as that happens before the court. This is Top Story News 9 in a minute.
Ever visited a shop, picked a